something else that's fun about derivative actions. They are not your typical action where you can simply run into court. So I'm going to break this down right now because, believe it or not, the law is a little bit different for corporations versus limited liability companies. Corporations in New York are governed by the New York Corporation Law. The plaintiff must have been a shareholder at the time of the alleged wrongdoing or obtain their status through somebody else. If, for example, wrongdoing was committed in December of 2023 by an officer of a corporation and the plaintiff became a shareholder in January of 2024, there's now an issue. The plaintiff will lack standing to bring the suit because they were not a shareholder of the company at the time that the wrongdoing had taken place. However, if that same plaintiff had obtained their shares from a wronged party and the rights of that shareholder were assigned to this new plaintiff, they then could bring an action so long as they satisfy the other threshold requirements under the New York Business Corporation Law. So aside from having proper shareholder status before initiating a claim, the demand requirement is that the plaintiff must make a written demand on the board of directors requesting that the board take action before they file a lawsuit. Now, the idea stems from the reality that courts are not business owners. Courts don't run businesses. Courts are not entrepreneurs. Judges are not involved in the day-to-day affairs of a company. So generally speaking, the courts don't want to intervene and meddle with companies. So that's the logic behind the demand requirement. The court will want to see that a shareholder made the efforts to have the board or the officers resolve the dispute prior to coming to court. There is an exception to this rule, and it's called the futility exception. The shareholders are not required to make a demand that the board of directors take action in the following scenarios. Number one, if there is a belief that the majority of the board of members or directors are alleged to have participated in the wrongdoing. If that's the case, then there is no requirement to first go to the board. Number two, if the board members are dominated or controlled by wrongdoers. So if the bad faith actors for whatever took place were actually involved in the company and are controlling or dominating the board of directors such that they're having extensive influence over them, the courts have carved out this exception where one no longer needs to make this demand upon the board, but instead you can go directly to court. And number three, the challenged transaction was not a valid exercise of business judgment. In this scenario, number three, the courts have discussed this rather heavily. There's the case of Marks v. Akers, which is a Court of Appeals, the highest court in New York, decision from 1996 that ultimately unpacked all of these futility exceptions. And in that case, the court specifically referenced this idea that what do we do in the scenario where a shareholder doesn't want to make a demand because the board's involved in the wrongdoing? Fine, that makes sense, you can run into court. If the board is dominated or controlled by the wrongdoers, that makes sense. No demand needed, you can run into court. In this third scenario, there is now this additional opportunity to go to court without making the demand if it's clear that the judgment or the decision that was made was not a valid exercise of what a reasonable person would do in the position of whatever this wrongdoer was. So the conduct alleged of has to be pretty darn egregious, but if you can show, for example, it's very clear that fraud was committed, then there's no need for the shareholder to go to the board of directors. You can simply initiate an action in court.